Good evening to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss Part C question relating to jurisprudence. Please refer to question paper 2016 and question number is 17. Brief facts are like this. The appropriate government made certain rules and regulations upon certain aspects. Totally vague question. The government made certain rules and regulations upon certain aspects. The main aim is to avoid child labor. Now the point has come. To avoid the child labor, the government made certain rules and regulations, and also to control the crime rate in the society. But some sections say that is infringement to personal liberty or things like that. So decide the validity, whether the question is, or the issue is, whether the appropriate government can make certain rules and regulations upon certain aspects. Yes, definitely they can do it rationally. So whenever, just like I told you, whenever the justice to be delivered, the judge should think in the justice, equity and good conscience model, right? So definitely the people who are not happy, they can contest the same, but normally since you are students, you have to write that yes, the government is competent to make some rules and regulations. Okay, now we'll go to the part of discussion. Particularly since this is child labor, right, and control of crime. So to avoid child labor, first of all, let us know what is child labor. Child labor means, the child labor is defined as the work that deprives the children of their childhood dignity and mental development. So if the child is made to work in the hospital, work in the hotel, work in the field, then his right to education is gone. So this is child labor. So government of India and the United States also, to avoid the child labor, so many acts are made. So because child is considered as the national asset and future of the nation. So this child labor is mainly discussed in the prevention of the child labor within brackets Prohibition and Regulation Act 1986. And second one is Juvenile Justice Care and Control or Care and Protection Act 2000. These two acts are more important. Time and again the amendments are coming, and definitely they are considered as the regulations. And the provision of the article in the Constitution, Article 24 of the Constitution states that no child before the age of 14 years shall be employed to work in hazardous process, to work in any factory or mine or any hazardous employment, right? So the Child Labor Amendment Act, that is Prohibition Amendment Act 2016, prohibits the adolescents. Who are the adolescents? People between 14 to 18 years of age to work in hazardous processes. So if it is allowed, then the mine's owner is liable for punishment, right? The punishment may be from 6 months to 2 years also. So Child Labor Amendment Act 2016, the government has regulated it in the case of adolescents also. Even if they are allowed employment in the hazardous process, hazardous environment, like mines in Chemakurti and other things, the employers are liable. And Article 39 of the Constitution of India, Directive Principles of the State Policy, it says the tender age of the children. So the tender age of the children, they should not, in the tender age, they should not be abused, and they should not be forced into the avocations unsuited to their age and strength. So this is likewise the bonded labor, and that is what it called Bonded Labor Act. When it comes, we'll discuss you. Bonded labor means 1976 Act. It says a person, bonded labor means a person who incurs to have incurred a bonded debt, even though he has not committed any debt because of servitude, because of his parents not able to repay the money. He has to incur the so-called debt. Section 4 of the Bonded Labor Prohibition Act, definitely it abolishes the bonded labor system. If you go on for the bonded labor, Section 16 liable is the punishment for enforcement of bonded labor. So 3 years punishment can be given. This is bonded labor. Here in the point why I have touched that bonded labor is servitude. This is what is called after servitude means, suppose a boy is studying 10th class or so, after completing the same he wanted to study intermediate. But the local landlord asks him that he has to work under his time, that is tractor, because his grandpa has not paid him the debt. This is what is called servitude. Then Factories Act 1948. In the last video, last problem, question number 16, we have discussed so much of lockout, then the so-called strike, retrenchment, all these topics. So according to Factories Act 1948, it prohibits the employment of children below 14 years in any factory. And the Minors Act 1952 prohibits children below 18 years of age to work in a hazardous process. And coming to the second act, that is Juvenile Justice Act. Friends, even though I told you touched the prohibition of child labor as well as Juvenile Justice Act, now we have touched so many other acts like bonded labor, then juvenile, this is Minors Act, Factories Act 1948. Now we are coming to the Juvenile Justice Act. Very important act. Time and again we are coming. So the first point I want to tell you is whenever any juvenile criminal is caught, you cannot call him as an accused. You have to address him as a juvenile in conflict with the law. Even the courts also should be held in the ICSES office, and also the police officer should not wear the uniform while interrogating them, and the police officer should be cautious to send them to the shelter homes. Even the judges need not wear the uniform. Of course, the advocates not supposed to wear the uniform. So you have to create a congenial atmosphere for the juveniles for the conduct of the trial. So please remember, Juvenile Justice Act, this law made it a crime for anyone to keep a child in bondage for the purpose of employment. So these are all the regulations made by the Government of India in these two acts. Yes, no doubt. In this connection, some parents may go to the court. Some parents may say, suppose if you do not allow our children to work in our tea stall, to work in our fields, then how our feeding will be done? Yes, definitely. This is also point in question. But still, please remember, the regulation, what for the regulation is made? The regulation is made to see that the children are forced into labor. That is the main intention. Therefore, please remember, according to the Child Labor Prohibition Act, yes, the child after completion of his school hours, he can come and participate in the father's or in the parents' avocation, like running of the tea stall like that. So that leverage is there. The regulations are there, but at the same time, there may be some exceptions also. So likewise, even there is a Juvenile Justice Act. A person is found as a juvenile, he will not be convicted. Maximum conviction is only 3 months, 3 years. Even though he commits a murder, he is liable for punishment only for 3 years. But of course, from Nirbhaya case, it has been enhanced. If a person between the age of 16 and 18 years, if he commits any crime, then he can be treated as though he has got knowledge of the offense. That is, so likewise, so many regulations can be made by the so-called government for the purpose of preventing the child labor and the exploitation of the children, juveniles. Now we'll discuss the case laws. Number 1, MC Mehta versus State of Tamil Nadu, 1996. So very famous case, firecrackers in Shivakasi, children are being expected, and he has highlighted the relation between the so-called penalty and poverty and child labor. Because the poverty, just now I told you, the children, the parents themselves used to send them to work in the firecrackers, then what happens? So this is regulation. This regulation is there. So please remember, the state has to protect the child from exploitation of the labor. This is what is given in this particular case. Then Seema versus state of NCT. NCT means National Capital Territory Region, New Delhi, 2015. So here the child was found working in a Vishwakarma Tempo Repair Center. So labor officer, he came, he checked and found the boy working in a factory, therefore he booked a case. The parents said, no, our boy has to go and feed the father who is an ailing patient. So, yes, of course, here the court has taken a liberal view and did not find the child and he has sent him away. Then did not find that Vishwakarma goes. Then Bachpan Bachao Andolan, very famous case. Bachpan Bachao Andolan versus Union of India, 2011. So Bachpan Bachao Andolan means the agitation for the safety. Bachpan Bachao, for the safety of the children. This movement was started by none less than the famous Nobel laureate Kailash Satyarthi. Very recently came to Visakhapatnam also. Kailash Satyarthi, very famous man. So, in this case particularly, he has highlighted the plight of the children working in the circus companies. The children are being sent to the circus companies, they are being exploited, they are being detained, because of course children, once they come out, they will not go back. So they are being detained, all these problems are there. In this connection, it is nothing but violating the rights under Article 21A, that is the freedom of the fundamental right of education. But in this connection, the Supreme Court, in its wisdom, what they have done, they have created an expert committee. The committee will discuss first with the parents. If the parents are willing to take back their children, okay, let them take away. If not, then send them to the schools of their choice. And then the avocations, they may not be in a position to study. Then they can be treated or they can be learned the trades or professions of their choice. And thus, they have to get back to the mainstream of the society. So definitely, laws will be there, regulations will be there. We have to accept them. So therefore, to conclude, you have to write the conclusion like this. The rules made by the government to avoid the child labor, as stated in the above case laws, so it is society is highly appreciable. And even though the challenge is there, but they cannot be sustained because the intention of the legislature, whenever we discuss the interpretation topic, we will come to know. So intention should be understood, and definitely I am sure for the good of the people, some restrictions can be made. Okay, with this I am concluding. Please read the case laws and cite them wherever necessary, not only in this case. So this is a welfare legislation, right? So rights, as far as jurisprudence is concerned, you have to state that this issue relates to the rights and liabilities of the particular of the children. Okay, with this I am concluding. Thank you.